So there were all those people who sent in the questionnaires, and the judge had 295 that he went through today. And here's where we ended up after going through the 295. It actually went into the 300s because there were a few numbers that were mixed in there that, kind of threw it off a bit. But let me show you what happened. Out of the 295, 66 advanced from the pool, meaning the rest did not advance because they had conflicts. They couldn't serve on the jury. They had health issues. There were other things happening that did not qualify them to serve on the jury. I will tell you that in this case, compared to the others, so many more had seen media coverage. So many more were aware of the case, had heard of the defendant, Lori Vallow Daybell, had watched Netflix or Dateline or whatever. And so because of that, they were not admitted into the pool. So 66 advanced to the next stage. What we're looking for, what the judge is looking for, is 12 jurors and 4 alternates. So a total of 16. He did raise that later on, wondering if that might be too many. And Trina K is like, no, Your Honor, I'd rather have that. So because you remember on the last trial, we lost 2 within the first 2 days. So 12 jurors, 4 alternates, and the process will continue tomorrow morning. After that happens, after you get the pool, the jury will be sworn in, ready to go by Monday. So that's kind of a synopsis as far as what happened with jury selection today. Again, it's interesting because they had 66, and there's a bunch of walk-in jurors they are expecting in the morning to come in that maybe didn't complete an e-questionnaire but came in to do it. And the judge had mentioned the idea that maybe they could just not have those people come in and just stick with the 66 pool. But both the defense and prosecution would have to agree to that. And Lori Vallow Daybell did not want to agree to that. So we'll be back in court tomorrow at 10. They'll go through the walk-ins, and then all of these 66 will come to the courthouse tomorrow at 1:15, and then they will go through voir dire, where the judge will ask some questions, Trina K will ask some questions, Lori Vallow will ask some questions, and from there, they'll pick the jury, and they'll be sworn in. And as I mentioned, we should be ready to go come Monday. Moves pretty quick. It's actually pretty efficient. And I actually appreciate kind of the way that it's done, because it goes so fast. I mean, literally some of these, the judge would spend 5 seconds on, 10 seconds maybe. But before all this happened, there was a kind of a last minute hearing that I didn't even know about. No one in the media knew about. It was thanks to one of you tipsters, Karen, thank you so much, who texted me this morning at 9:26 and said, hey, isn't there a Lori Vallow Daybell hearing at 9:30? I was sitting here in my room on my bed making some graphics, and I look at the calendar and I'm like, oh, there is. I'm about 15 minutes from the courthouse. I immediately texted Justin Lum. His news station is right by the courthouse. He said it's happening. He rushed down there. We all missed it. It was a last-minute hearing called in front of a different judge to address Lori's motion about Judge Beresky being removed from the case. She has filed this motion. She doesn't want Beresky on the case. A different judge had to hear it. And here's what happened. Now, we were able to get video from the court camera system. It's not good quality video, but the audio is good. And I just want to play for you how that judge ruled and what happened this morning.
Good morning, everyone. The court calls CR 2022-00124201. This is State versus Lori Daybell. Appearances, please.
Trina K on behalf of the state, and for the record, the victim is appearing virtually.
Thank you.
Lori Daybell for the defense.
And Pamela Hicks, advisory counsel.
Thank you. This got set very quickly. There was a media request that I became aware of in passing, literally on my way over here. I don't have a written request. I have not read all my email because I've been on the bench this morning. Do you want to make a record with regards to the media request from the state?
No, Your Honor.
Okay, from the defense?
No.
Okay. I don't see anyone here. I thought we would address it on the record, but I don't see anyone present from the media. Okay, I assume there's no objection if they come in. Ms. K?
No, Your Honor.
Ms. Daybell?
I always object to them, yes.
Oh, you object to them?
Always.
Okay. Is there anything you wanted to put on the record?
No.
All right. My thought is if they come in, we can address it. All right. The court's, this is the oral argument on Ms. Daybell's motion for change of judge for cause. The court's in receipt of and has reviewed motion to disqualify judge. This was filed on May 20th, and the state's response to defendant's motion to disqualify judge. Ms. Daybell, I've read your motion. In summary, the way I read it, you're asking for the court to remove Judge Beresky for cause under Rule 10.1. You cite several reasons, specifically that he's denied various motions. You mentioned facial expressions. You mentioned a belt and his not allowing you to remove it. You assert that he violated your speedy trial. There's a mention of religious persecution and an allegation of personal bias. So you're going to get, and then the state's response is that simply the defendant does not establish judicial bias, appearance of bias, or fundamental error. Of course, under Rule 10.1, the court is evaluating whether or not Judge Beresky can be fair and impartial and whether he can conduct a fair and impartial trial in this matter. So I'm aware of the allegations. You'll have the opportunity to go first, then I'll allow the state and to address the court, and then you'll have the last word. Whenever you're ready, Ms. Daybell.
Okay. I did file this motion in this.
I'm sorry, can you pull the microphone? I'm sorry, I can hear you.
Sorry. I did file this motion in this affidavit after several attempts to. I made an oral motion with Judge Beresky and asked him to recuse himself because of the bias and prejudice that I had seen during our last trial and throughout the whole entire time that he has been the judge over all of these cases. And he refused to do so. So I thought I needed to put it in writing and put all my points in that I felt like were causing him to be biased and prejudiced against me, and that obviously you've read it, so you've seen all the different things that I put. There was an actual comment during trial when I was cross-examining one of the witnesses where he said to me directly after an objection from this state that I was comparing myself to biblical prophets, which I absolutely was not doing, and I didn't even realize it until someone showed it to me on the FTR afterwards that he had even said that, because I was in the middle of questioning the witness. And so there's several times that he made comments directly to me. I tried to address this with him directly in our last hearing on May 14th, where I asked him why he had denied every single motion that I had ever filed in the last year and a half. And he said that my motions had no merit. I asked him if my prior defense team, that he denied all of their motions, that they had no merit as well. And then I asked him, my prior defense team before that, all the motions they filed were denied, and did they have no merit at all either? And I asked him again if he would recuse himself from this case so that I could get a judge that was impartial and fair and have a fair trial. That is my right, my 6th Amendment right and my 14th Amendment right to have a fair trial, an impartial trial, and not a judge who has some kind of bias against me.
All right, anything else? Thank you.
Judge, just the prior defense motions almost all exclusively dealt with motions to preclude the media. Judge Beresky applied the appropriate law in finding that the media had a right to be present and tried to limit it by saying things like they couldn't focus on the defendant's papers or things like that to mitigate any of the concerns by the defendant. All of the defendant's motions that she has filed have been without legal basis. They've been appropriately ruled on, and the state's motions that the state has won have been ruled on based upon, again, legal basis. So the fact, as the court is well aware, that the defendant has had all of the motions ruled against has no basis for bias if they're all been ruled on based upon the rules of law and the rules of evidence. So we see nothing that the defendant has provided here that would rise to a level to preclude or recuse Judge Beresky from this case.
Thank you. Ms. Daybell, you can have the last word.
Yes, also, along those lines, Your Honor, that's one thing that I asked Judge Beresky, is that he has denied all these motions with no finding of fact and no conclusion of law. I said, what is the finding of fact and conclusion of law? These are just denied, 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 denied. He's also denied several attempts for me to try to ask the state for discovery that he's just denied outright. And then as I keep filing more and more, as I find out what we don't have and I ask for it, I'm continually, even to last week, getting brand new discovery with brand new Bates numbers, stuff that they realized they never even had before that hadn't been turned over. And I've been asking Judge Beresky for these items for a year and a half. And I'm getting them 1 week before trial. We start picking our jury today. We're supposed to be doing our strikes today. And along those lines, I had this motion about the RAC belt that I had asked him about since we went through this whole trial, and there was times when the belt didn't fit around me, so it fell out of my clothing, and we had to stop trial, and I had to go fix it. And that is what MCSO recommended, that if that was too burdensome, that they would put an armed guard in the back. And because of the media that Judge Beresky has let into every single one of the hearings and the trial, that they already have an armed guard back there. So it wasn't going to cost the state any more money. It wasn't going to cost anything if he just had them remove the belt and went over the security that the MCSO actually recommended. Every single thing that I asked for has been denied. I feel like he does have a personal bias against me, and all I'm asking for, I went through a whole trial with him, even thinking he was biased against me before the trial started. I filed for a new motion because it came to our attention through the media. The media sent Judge Beresky a clip of one of the jurors saying that he found out about my prior convictions beforehand, before his deliberations. And this is the same exact juror who was brought in twice during trial by Judge Beresky, where he had to admonish him for, one, being on his phone, and two, talking to one of the other jurors about the case. And now he's saying, well, he went on another media thing and said that he took it back. He took back what he said, so I'm not going to give you a new trial, and nothing was done about it. He refused to call them in and have a hearing and put him on the stand under oath and ask him if he found out this information prior to deliberations. It was very confusing, and everything is just outright denied. I want to go to trial. I want to have a fair trial, as fair as possible. I don't feel like I can do that with Judge Beresky, and I would like to be appointed a new judge who wouldn't know anything about the case and be fair and as impartial as possible. Thank you.
Thank you. I've considered the written motion and the response, and certainly your comments today from both sides. Ms. Daybell, I find that the fact that you disagree with Judge Beresky's substantive legal rulings is not a valid basis under Rule 10.1 to grant your motion and give you a new judge. The standard in 10.1 is, has he demonstrated he can't be fair and impartial? And the fact that his rulings have not gone your way is not a valid basis to suggest that he can't be fair and impartial. Unless there's some other allegation of bias that's been demonstrated, I don't find on this record that it has been demonstrated. I certainly understand your frustration with the way that the rulings have come out, and it sounds like the way that they came out with prior counsel, but the things that you have cycled through at length in your motion to disqualify, I've considered all of them. Whether or not he should have ruled differently, for example, the example you gave with the juror, or with making findings of fact and conclusions of law in writing, some of the issues you have, if you have concerns about his substantive legal rulings, you can file a motion to reconsider, or you can take them up on appeal. You can file a special action. You have a number of legal remedies at your disposal where you can make those arguments, but they're not grounds under Rule 10.1 to get a new judge. So I am going to deny your motion. Again, as for your concern about his substantive legal rulings, you can address those concerns in a different way, but it would not be under a 10.1. And on this record, I don't find that he's demonstrated that he can't be fair and that he can't be impartial. I also wanted to address the comment that he made that you illustrated. That comment alone doesn't demonstrate that he can't be fair and impartial. I'm not exactly sure of the context where he made it, but it sounds like he let you ask a question with regards to religion, and that was his decision. But again, I don't think even that demonstrates that he can't be fair or impartial in this case. All right, so I'm denying the request to disqualify Judge Beresky under Rule 10.1. Is there anything else from the state?
No, Your Honor.
Anything else, Ms. Daybell?
Nope.
Thank you, we are adjourned.
All right, so there you go. Denied, and then a few hours later, Lori was back in front of Judge Beresky. Now, that's when we did the jury selection portion, which cameras were not allowed in. We have no video of that. And then the judge said that there were a few outstanding motions that he wants to take up tomorrow. And then he said anything else, and Lori said, I have 3 things I want to talk about. You want to do it now or tomorrow? The judge said we can do it now if you want. And this is when the big thanks to Fox 10. They're the pool camera, so they represent all the media. They were on standby, thank goodness. And so he pulled out his camera, and the judge started to talk. There was a little bit of the proceeding that we didn't get on tape, but the rest we did. Let me explain this to you as far as I understand it. In Arizona, about 10 to 15 years ago, from what I understand, there was a rule passed that if somebody, so there's the trial phase of the trial. The jury then goes back, and all they decide in a serious matter like this, in a felony murder, is whether the person is guilty or not. If they are guilty, there's then an aggravating portion that they then decide if there are aggravating factors. And then if they decide, yes, that could increase the sentence that the defendant gets. In Idaho, we saw an aggravating factor during Chad's trial, but they only do that in death penalty cases. In Idaho, how it worked with Lori, she was found guilty. The jury doesn't determine if there was aggravating factors or not. If it was a death penalty case, the jury doesn't determine if there's an aggravating factors in Idaho unless it's a death penalty case. Lori Vallow's case was not death penalty in Idaho. So she was found guilty, and then the judge issued the sentence. In Arizona, you might recall in her last trial, the prosecutor did file to have an aggravating portion part of the sentencing phase. I hope I'm making sense, because honestly, I did not understand this until the last trial. They don't want the jurors, and Judge Beresky here explains it in a minute, they don't want the jurors to focus on, are there aggravating factors or are there not, during the guilt phase of deliberations. They simply want them to focus on the guilt or innocence phase. If they determine guilt, they will then decide, and there'll be another mini part of the trial where witnesses could be called. In the last trial, Lori waived that. She didn't want the aggravating portion. She waived it, and the jury didn't have to worry about it. And Lori has an issue with the fact that she wants a hearing to determine if there are the aggravating factors before it gets to the jury. But she's not entitled to that. And she didn't quite understand it. And from my observation, and you can see here what happens, and she gets quite heated with the judge. And I'm going to play this out for you. The whole hearing, there's some other matters we'll talk about in a minute. I'm just going to play the aggravating factors portion. The whole hearing was about 20 to 25 minutes. And you can see that she's got questions. And at the end of the day, she does have a point in the fact that it really doesn't matter if she's found guilty, because on this case, she'll serve, I believe it's 25 to life. So whether there's 15 aggravating factors, it very well could be that if they find 15 aggravating factors, the judge automatically says, you get life. She's going to Idaho anyway. If there aren't any aggravating factors, maybe the judge rules on the lower end, the 25-year portion. Whatever it is, but Trina K makes the point that she wants to be sure she has aggravating factors on the record for appellate purposes. I'm explaining it all. Why don't I just play it out for you? Here's the interesting part of today's hearing.
Aggravation phase, from my understanding that we did over my objection last time.
Well, we actually didn't do an aggravation phase.
Well, I stipulated to it.
You stipulated to it.
Correct. But in adding it to, at the end of trial, a whole guilt phase for aggravators, my understanding is that in January, the state filed their motion, the state's allegation of aggravating circumstances, right? And then my understanding is that that can be brought to the jury during guilt phase. And so, but it hasn't been dropped to them yet because it's after the indictment. So it needs to have probable cause hearing, which is the 13.5 hearing. So we need to have a probable cause hearing so that we can add that to the guilt phase, and that's something that gets taken to the jury after probable cause has been found for these aggravators that are alleged.
I think you're referring to the rules for capital cases when there's aggravators filed in death penalty cases.
Correct.
You're entitled to a probable cause hearing, depending on the aggravator. This is not a capital case.
I know it's not a capital case, and in normal capital cases, you don't have an aggravation phase either, right? Only in a capital case.
Actually, you have a guilt phase, and then you have a mitigation aggravation phase.
Actually, you have a guilt phase, an aggravation phase, and a penalty phase.
Right.
If the aggravators aren't found as a completely separate independent hearing, then there's no penalty phase.
So with the statute for this charge only being the one statute, what are you getting out of the aggravation phase? I don't understand.
Well, first of all, the jury in the initial phase doesn't determine whether or not it's a dangerous felony, which they need to find. And then the aggravators, I think the state has a right to attempt to prove those to the jury, to offset any mitigation or to be weighed against mitigation at your sentencing.
And isn't that normally put together with the guilt phase? Like they would have that on the back page where it says the aggravators and the guilt?
No.
So are we going to have a whole nother aggravator phase in this case?
If the jury finds you guilty of the charge and the state wants to proceed with aggravators, yes.
And so we do not have to have a hearing to determine if there's probable cause for these aggravators?
No,
They're just alleged aggravators,
correct,
and the grand jury never found probable cause for them.
correct.
So you're saying that if the guilt phase goes through and they find you guilty, then you have an aggravator phase added to that?
That's what I said.
Okay. Hold on one second.
You have the allegation of aggravating.
Okay.
It was on my desk.
Your Honor, I would just like it to be on the record clear that the Rule 13.5 that I'm talking about is about non-capital cases. I know in capital cases, they call it a Cronus hearing, but this is for non-capital case?
Well, it says under 13.5A, a defendant may challenge the legal sufficiency of the state's allegations by filing a motion under Rule 16. Is that what you're talking about?
Correct.
It doesn't say you get a probable cause hearing regarding the aggravators.
Well, I'm challenging the state's allegation of aggravators by asking for a 13.5 hearing on it.
So the state's aggravators that they've alleged is that the offense involved the infliction or threatened infliction of serious physical injury. The offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of the crime, specifically a gun. The offense involved the presence of an accomplice. The offense caused physical, emotional, or financial harm to the victim, or if the victim died as a result of the conduct of the defendant, caused emotional or financial harm to the victim's family. The next one is the defendant was previously convicted of a felony within the 10 years immediately preceding the date of the offense. This one's really not very specific. Any other factor that is relevant to the defendant's character or background. So if you were found guilty by a jury of conspiracy to commit first-degree murder, which of these aggravators do you think there's not legal sufficiency for a jury to determine? Because they seem pretty inherent in the charge itself, except for your prior convictions, which, are you saying you don't have the prior convictions within 10 years?
No, I'm not saying that. Which of them don't qualify for the jury to make that determination?
No, you're asking for me to make a determination that there's a legal sufficiency for them to go to the jury.
Correct.
So I'm asking you, if you were found guilty by a jury of the charged offense, which of those aggravators that have been alleged by the state do you think there would not be legal sufficiency for? Because as I look at those aggravators, most of them are inherent in what you're being found guilty of. Again, if the jury found you guilty. For example, the first aggravator, it involved the infliction or threatened infliction of serious physical injury. The allegation is someone shot at the victim. That's the threatened infliction of serious physical injury. So it seems like that allegation, there's sufficient evidence for a jury to decide whether that's an aggravator. The next one, the offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of a crime. Again, if you were found guilty of the charge, as the state has alleged, the jury would find that a gun was used. So that's a separate aggravator, again, that would already be determined by the evidence. The state has alleged an accomplice, your brother. If the jury were to find you guilty as charged, again, my understanding of the state's allegation is your brother attempted to shoot Mr. Boudreau. You weren't in Arizona. So if the jury found you guilty of this charge, it would mean they found you guilty as an accomplice. If someone shot at the next aggravator, I don't think it's a leap for a jury to presume there's some sort of emotional harm. So I'm struggling with what legal sufficiency you think is lacking for a jury to make those determinations. Again, only if the jury found you guilty of the charge that you're charged with.
I understand, Your Honor, but in 13.5, right, whether capital or non-capital, the state has the burden to establish probable cause, the legal sufficiency of an amended indictment. This is an amendment. This didn't go to the grand jury, is that correct?
Right.
So now I have the right to ask for a hearing so the probable cause can be found for these aggravators ahead of time.
So you're confusing two things.
Okay?
All right. 13.5B talks about amending the charge or the indictment. Okay, your charge is conspiracy to commit first-degree murder. It's not, your charge is not being amended. The grand jury did find probable cause for that charge.
Correct.
An aggravator is not an amendment to the indictment.
It's a whole nother allegation. It's a whole separate allegation.
Difference between an aggravator and changing the charge that you're charged with. If the state were to change the charge that you're charged with, for example, if they changed it from conspiracy to commit first-degree murder to conspiracy to commit second-degree murder, there'd probably need to be a new probable cause finding.
Correct.
Secondly, as to the allegation that it's a dangerous offense, the grand jury did make that finding because that allegation was included in the indictment that it was a dangerous offense. So there has been probable cause as to the dangerous factor.
Okay, if that is the case, then why isn't that found in the original guilt phase as opposed to having a whole nother aggravation phase after that, as if it's a capital offense? Because there's one statute,
Well,
there's one sentence, there's no arguing the sentence, and if it's already a dangerous crime, then there's no reason to have an aggravator phase.
What do you mean there's no arguing and there's one sentence? I don't understand what you're saying.
There's one sentence for
Oh,
the charge. There's only one sentence for this charge. And if it's already classified as a dangerous charge, is what you're telling me, right? Because it's conspiracy to commit first-degree murder, that's a dangerous charge. The jury has already found that it's a dangerous charge. Then what is the aggravator phase finding? If it's already a dangerous charge and there's only one sentence.
Does the state want to respond why the state wants to proceed with aggravators?
To start with, the jury is not going to make a finding of dangerousness as part of the guilt phase per case law. That's not permitted. So the jury has to make a separate independent finding after they find the defendant guilty. The dangerous finding will include the use of a weapon and or the intentional infliction of or threatened infliction of physical injury. So at the very least, the jury has to make a finding as to dangerousness.
I agree about dangerousness. I guess the question is, why does the state want to prove up aggravators if the jury finds the defendant guilty of the charge as a dangerous offense, given the sentence?
Your Honor, in all honesty, you could ask me this, 10 years ago before Blakely was put out. As case law changes on appeals, I've had to come back before and redo a penalty phase, an aggravation phase, and re-impanel a jury. So I prefer to, since we're already going to have an aggravation phase for the dangerous allegation, to add on the other factors, and therefore I don't have to ever worry about this coming back on appeal later.
All right.
How is it not already found to be dangerous? You just said that if they find me guilty, then it will be dangerous.
I didn't say that. I said if they find you guilty, then they make a determination whether or not it's dangerous. Now, I think what I meant was when a crime involving a weapon is used, whether it's a gun, usually it's sort of a foregone conclusion that if the jury found you guilty of conspiracy to commit first-degree murder by someone shooting at another individual, that they're 99.9% likely to find that it was a dangerous offense. But it's something the jury has to do.
Right, but usually aren't aggravators for sentencing? What other purpose does it serve in this case with this charge, with one statute? You can't give me less time, you can't give me more time, you can't do anything else except for, it's one statute.
I guess the prosecutor's saying she wants to cover her bases in case there's some change in the law and what a jury has to find or not find for purposes of sentencing. And they have the right to proceed with aggravators. All right, you're right in that if you're found guilty of this charge at this level, you get one sentence. But who knows what a court of appeals would do in the future if aggravators or things weren't presented. I don't know that what would be presented at a sentencing phase from your side or from the state's side, but it sounds like the prosecutor's wanting to cover her bases.
So then I'm not entitled to a hearing before trial starts to find probable cause for these aggravators that were not taken to the grand jury initially?
All right,
I'm asking.
I'm trying to explain it to you. The jury did find probable cause that this was a dangerous offense. It's included in your indictment. So they did find.
They didn't find these specific aggravators. Being a dangerous offense and these specific aggravators
Can I finish what I said,
different,
what I was saying?
right?
I didn't interrupt you. Can I finish? Okay. The jury did find probable cause on the dangerous allegation, all right? You're not entitled to a probable cause hearing on the other aggravators.
When is conspiracy to commit murder not a dangerous crime?
When someone says they're going to choke someone to death and they don't actually do it, it's not a dangerous crime.
So
No dangerous instrument or deadly weapon was used.
So because some instrument may or may not have been used in this crime, it's considered a dangerous crime?
Right.
And these aggravators that talk about something totally different don't have to be found after that it's found a dangerous crime?
Correct.
And that is supported by case law?
Yes.
So that what? When you go to appeal, you can't say it was a non-dangerous crime?
All right. I don't know what to tell you, all right? There was a case that came out about 15 to 20 years ago now called Blakely that said a jury had to determine aggravating factors. Okay, before that, a judge determined aggravating factors at sentencing. Now a jury has to determine it. The reason it's not done in the guilt phase is we don't want the jury to confuse the issues. We want the jury to decide first whether someone's guilty or not guilty, whether the state has proved its burden beyond a reasonable doubt. We don't want them to start thinking about other things like aggravators if they have questions about whether or not the person's even guilty. It tends to confuse the jury and confuse the issues for them. So that's why we do the aggravators in a separate hearing. First, you want to make sure the state has proved its burden beyond a reasonable doubt as to your charge.
But these specific aggravators that they allege, right, the ones that you just went over, you're saying that now after you're found guilty of a dangerous crime, that they're going to go back in, and what is the purpose of that? How does it change anything after that?
I don't know how else to explain it to you. So do you have other issues that you want to bring up today?
Yes, but I would like to finish this first. So are you denying my motion to have a hearing on this?
I'm denying your motion to have a probable cause hearing as to the state's alleged aggravators.
Okay, so you're denying my motion to have a 13.5 hearing on these alleged aggravators
Correct, because
before trial starts.
you're not entitled to one.
Okay,
13.5 says that you're entitled to a probable cause hearing if they amend or change the indictment.
this is not an amendment of the indictment?
It's not. There's a difference
It's an
between,
extension of the indictment. It's not in the indictment.
it's a difference, okay, between an aggravator and changing the charge that you're charged with. Changing the charge that you're charged with is an amendment to the indictment. For example, if you were just charged with conspiracy to commit first-degree murder, all right, but the state didn't allege with the grand jury that it was a dangerous offense, you'd be entitled to a probable cause hearing as to that dangerous allegation because it's changing the charge and it's changing the sentence that you would be getting. These
That's
aggravators,
exactly my point. After the fact, these aggravators, if they're found, what do they do to change the charge or change the sentence or change anything?
probably nothing in reality. You just said it. They don't change the charge, so you're not entitled to a probable cause hearing.
Okay, then I don't want to have an aggravation phase either.
Well, you can
How
not.
are you entitled to that? And I'm not entitled to a hearing on probable cause, but you're entitled to have an aggravation phase.
Okay. Well, if you don't want to attend, you don't have to attend. What else?
Okay, I gotta tell you, I've covered news for almost 20 years, 20 years in January. My first 3 years in TV, I went to hundreds of court cases. I don't think I've ever seen anything like that. Although I just realized when I said that, I did once. I wasn't there. I have the recording where a defendant was found guilty and he told the judge to F himself and he wanted to be sentenced now and he was hauled out. That was probably the worst. Lori's not comparable to that at this moment, but I keep wondering, and I've talked with many people today, wondering if this is the Lori we're going to see during the trial, where she's going to come out with arms swinging and just have questions a lot. Now, at the base of it, as I said, I can kind of understand the argument of why have an aggravating factor portion of the hearing if I'm found guilty and if state law already says what I'm going to get. It's not like the judge could say, okay, you can get probation or you could get life in prison. And in the middle of it all, we're going to hear the aggravating factors and that might persuade it. There's a set sentence here in Arizona. So she's either, going to get 25 years or life or something in there. So I kind of get what she's saying, but this is an issue that is beyond Judge Beresky. This is an issue that according to the Arizona state law, they're just doing what the law says. It's not like they can do anything. She's saying that they changed that they amended the indictment after the grand jury had it and they didn't explain the dangerous elements to the jury, and the judge is saying no. And anyway, we won't spend any more time on that, but that was an interesting thing. Now, Lori Vallow had two other things to say to the judge, two other issues she wanted to bring up. And this is much shorter. I promise it won't take long. Here's how that went.
Something dealing with trial is that I've asked several times for headsets for my advisory council. I know that's been an issue that you said we can only have 5 headsets. Is there some way we can do that? Because it's very difficult for them to advise me on things when they kind of don't know what's going on.
If you need a break to consult with your advisory council, we can do that. I can only give so many headsets.
You said you were going to check into that. Is that something that
They
you did
said
check
they-
into and
they
there's no
can't
more
do-
available headsets?
They can't do more than 5 on that particular system or network that they have. I need my court reporter to have one so we can do the sidebars. The state's only getting 1. I get 1, so that leaves 2 for you. Whoever you want to have besides yourself, you can choose one of your advisory council or your paralegal.
But you're forcing me to choose between the people that are helping me?
Sure.
Okay.
Technically, I don't know I even have to do that. You represent yourself. You're considered your own attorney. You don't even have the right, the right to consult. I shouldn't say that. You have the right to consult with them, but it's not a necessary thing. Because you are acting as your own attorney, you're expected to proceed as your own attorney. They don't have an affirmative duty to even give you advice under the case law for being an advisory council. The fact that they do is probably helpful to you, okay? But you chose to represent yourself. It means you are supposed to act as your own lawyer.
You appointed them and assigned them to me. I did not ask for them.
Okay, yeah, I did, in case you decided not to represent yourself so they could step in at trial.
Okay, well then, is an alternative that we could do sidebars at the bench so that they could be involved during
I
that
think it
time?
depends on the complexity of the question. If it's a simple jury question that, like, for example, can we have a copy of the police report? The answer to that is always no. So I think I'll have to take it on a question by question and issue by issue basis. So if it's an issue where we need everyone at the bench, yes, we can do that. But if it's a simple, quick response that we can do with the headsets, we'll do that.
Okay. I have one more issue.
Go ahead.
Okay. Seeing as how things went in the last trial, my question is, what does the state intend to bring in from Idaho so that I can prepare my questions without being accused by you of opening the door? How can we avoid that when almost every witness has testified in my Idaho trial? And I don't want to be responsible for doing that, so how are we going to handle that?
Well, I will tell the prosecutor to make sure a caution is given to each witness that no matter what the question is, that witness should not think it's a question that would require an answer about prior testimony or prior proceedings. State agrees, right?
Yes, Your Honor.
I guess they can be further advised that if they think you or the state is asking a question that calls for that sort of answer about prior testimony or a prior proceeding, that maybe we should take a break.
Okay,
All right? Anything else?
that was it.
All right, we'll see everyone.
Okay, there you go. Back in court tomorrow. Many of you are asking, who's the guy in the jury box? That's one of the judge's assistants. He was actually in the back. He came to give the judge some stuff, and I think he was just sitting over there. And then he has another assistant who's over on the other side of his bench. So that is what happened today. Now, where do we go from here? Well, actually, I'll tell you. Again, jury should be finalized tomorrow. We'll be back here tomorrow night for Courtroom Insider. Trial begins June 2nd. That's Monday. I'm going to start giving live written updates beginning at 11:30 a.m. Mountain Time on eastidahonews.com and on my X account. The video will begin at noon. Again, there's a 30-minute delay. For those of you brand new to this, you're wondering what? The judge has implemented a 30-minute delay before we're able to feed out any video to you. That's in case a juror is accidentally shown or something is shown on the screen. It can go back and be edited, a phone number or a social security number or something. So the court will actually start at 10:30 Arizona time, and then at 11 Arizona time, we'll start to feed it. We're going to go live on our YouTube channel about an hour before, and I know all of you like to hop on and chat, which is kind of fun. As I'm in court, I'll look down and see what you're saying in between my tweets, and Peggy's on there interacting. So feel free to join, and if you haven't subscribed, hit the subscribe and the bell, and that way you know when we are live. So the video will start at noon Mountain Time on our YouTube channel. It'll go all day, and then we'll be back here every night, Courtroom Insider, live from Phoenix at 8 o'clock Mountain Time. That's kind of the schedule for all of you. what you can do if you want to figure out if you're watching overseas, type in to your Google when it's 11 o'clock in Idaho Falls, what time is it here? And then it should tell you. Okay, I hope that helps because Idaho, there's a sliver of Idaho that's in the Pacific time zone. And Arizona is in the mountain time zone, but doesn't observe daylight savings. So it's always this kind of weird thing figuring it out in the summer months, who is doing what. I got to thank our sponsor tonight, newspapers.com. I was thinking today as I was driving home from court, by the way, we're going to get to your questions and your shout outs. I have them ready. And Peggy's gathering them. What was your first job? Do you remember your first job? Mine was collecting and delivering the Green Sheet newspaper. It came out once a week on Thursdays. We'd get the stack of papers. I'd get home from school. I would fold them and I would stick them in the black plastic bags or put a rubber band around them. And then I would go deliver them. And it was a free paper. But in order to make money for the newspaper and in order for me to get paid is once a month, we would have to go out and collect. So we knock on the doors and we would say, "Hi, collecting for the Green Sheet," and the person would give $1. Can you remember those days? $1 for the newspaper. And then I would take the money, and I think I had to give half of it back to the company, and I got to keep half or something. I'll always remember one month I got $40. I was so excited. I got $40. Well, then I started to deliver the Salt Lake Tribune, the early morning newspaper. Although I thought when I signed up that I would be delivering the afternoon paper, the Deseret News. In the Salt Lake area, there's two newspapers. One was delivered in the morning, one was delivered at night. I thought I had an afternoon route. No, it was a morning route. I lasted about a month, and then I couldn't do it anymore, riding my bike in the winter, delivering these newspapers. Anyway, I don't know if I should tell the story. Maybe I should. Do you remember? I guess I will. I'll tell you all. I'll give you a big apology that I shouldn't have done this. But one time in the newspaper, do you remember when Monopoly was launched at McDonald's? And this was like mid 90s. And Monopoly was a brand new thing. And every time you'd order like a French fry or a drink or a hamburger, you would get a piece, like 2 pieces. And what they did is in the newspaper, they put a Monopoly board, like on paper, with 2 tabs, 2 of the properties that you could pull off. And most of them was a free food item and then a property. And so you'd build your board. My sister and I went through all of our newspapers. I can't believe I did this. And we pulled out all of the McDonald's ads. And then we built our Monopoly boards. We didn't win anything, but we had like all the properties except one of each color. And then we had a stack of Monopoly tickets for McDonald's free food, like hamburger, French fry, drink, whatever. And then we rode our bikes to McDonald's like every day for a month. It's so funny that I didn't get tired of it. And now I can't even like have a McDonald's hamburger without feeling sick. Sorry, McDonald's. Anyway, I got sidetracked there. The whole reason I'm telling you this is because I have a special place in my heart for newspapers, and newspapers.com is sponsoring us, and they are a great resource. We do a looking back column every week on East Idaho News where we look back in history at some cool things, and we get that information from newspapers.com. I think they have over 1 billion pages on their website for newspapers in America, Australia, the UK. You can go check them out. Big thanks to newspapers.com for helping us out this trial. Also, Teton Toyota, they're getting me around in my cool Camry. We talked about it today earlier when I went live about what should we call it, the Courtroom Camry. Somebody said, call it deny, deny, deny. Someone said, I got to check my text. I got a great message from someone. She said, you should call it, I'm done, I believe. Oh, done. Call it done. There's a lot of creative names. You guys are interesting. So thank you for to Teton Toyota for helping us out with the car. Okay, let me do some shout outs. So glad you are all here. Maria from Argentina. Serious. Wow. Bonita from Australia. Ellen J from right here in Arizona. Natalie from Akron, Ohio. I was born in Canton, which is near Akron. Trudy Turner from Michigan. Brittany from North Carolina. Heidi Weimer from Rexburg, Idaho. Hi, Heidi. And Land Jumul from North Texas. Thanks so much for watching, you all. So good to have you here. Let me do some questions here. Tiffany says, knowing how the state ran their last case, my question is, do you think Brandon will testify in the beginning, middle, or end of trial? Oh, that's a good question, Tiffany. I could see him being first and setting the stage, or being last and being memorable. If I had to bet on it, and I don't have any inside intel, I would think he'd be first toward the beginning and really set the stage and paint the picture of how he was on his way home from the gym when he was shot at. That's memorable when you have the victim on the stand. And then end with like a cop or something, which is what they kind of did in the last one. But I don't know. We'll see. Melanie or Anne asked, where is Melanie, the niece, living now? She's living here in Arizona. Of course, she remarried Ian, and yeah, they're living in the area. I don't believe we'll see her at the trial, and she's kind of laid low and is raising her kids, and I think trying to put this all behind her. And I know many of you have asked if I'm going to interview her. I'd love to interview her. I've extended the invitation to her, and I hope that happens one day. Natalie says, is Lori watching your Courtroom Insider? Is she allowed access? She's not allowed access to the internet, but her attorneys could show her anything they wanted. I know in Idaho, they showed her the Dateline episodes. They showed her Sins of Our Mother. They showed her other media coverage. She knew she was on the cover of People magazine, and maybe they're showing her every night. Lori, if you're watching, hi, let's talk. Come on, Courtroom Insider. You can call me one night. We'll do a live phone interview, and we'll open it up to questions from our viewers. You all can ask her a question, and we'll see what she says. I don't think that's going to happen. Could you imagine if suddenly she did call? Anyway, she's not given the internet in jail, and I believe they transport her over very early to the courthouse so that she can be ready for trial. We had somebody send us a box for Lori. I don't know if I told it to our newsroom. It was like a box of food and some clothes for her, and I didn't know what to do with it, so it's sitting there. Marilyn or Marilis, what happened to the items from the storage unit? The police seized those items after we went in there. They took all of that. I believe they kept it as evidence in case they needed it. And I think it may have been turned over to like Kay and Larry. I need to double check though. I'm not sure where. I know that they took them. And the reason the storage unit facility, one of the reasons he called me is he knew it was in the news, but also Lori hadn't paid her bill. And what happens on those storage units is if you wait, I don't know, 60 days, 90 days, whatever's in the contract, they auction it all off. Well, he didn't want to dump it. He didn't want to get rid of that stuff. And they didn't dispose of it, but it is somewhere. I just don't know where. Do you know if the gun that was used to shoot at Brandon is the same gun that malfunctioned while shooting at Tammy Daybell? Ooh, that's a good question. I could see it being the same one. I don't know. But Brandon was around October 1st, 2nd, October 1st and 2nd. Tammy was shot at October 9th. We know that it malfunctioned most likely because Tammy parked in a different driveway than she normally parked. And that meant Alex, who was in position, had to then run to shoot at her. And because of that, the expert, Nick Edwards, testified that particular gun, if you jostled it, if you shook it a little bit, the pins could become misplaced, and therefore it's not going to fire, and you get that whooping sound when you shoot the gun, like a paintball, which is probably why Tammy thought it was a paintball gun. I don't know if it was the same weapon, but that'd be fascinating if it was. How is Emma Daybell still depositing money into Lori's commissary account? Helen says. I don't know, Helen. I don't know if she is. I would doubt that. But maybe she is. I believe she's helping her father, Chad Daybell, with money, but I don't think she's depositing money. And how is she doing it? Anyone can do it. Anyone can, as long as you have their account information, you can send money. And I know there are people that do it. And I know she asks for it. Penny, would you ever interview the Daybell kids if they would concede? Absolutely. I'd love to talk with Chad's kids. And I think I would be fair to them, and I would hear them out and ask them, some questions and hear what they have to say. But yeah, I'd love to. Hi, Nate. We live in British Columbia, Canada. My wife and I have followed you from the first time you went to Hawaii on the Vallow Daybell case. Could you please give a shout out to my hero and my wife of 54 years, Joy Nikiforik? Joy, thanks for watching. I bet you're a joyful person. To be married to your husband for 54 years, you have to be a joyful person. Just kidding. I don't know him. Thank you so much for watching in Canada. And I appreciate that. Joy and Vic. Amy and Mesa, why was Lori in orange and cuffed for the jury? She wasn't. Today, the jury was not in there. The only time she can dress in normal clothes is when the jury's present. So today was outside the presence of the jury. So she was in cuffs, she was in leg shackles, and she was in orange clothes. When the jury arrives on Monday, she will be dressed up and she will have that rack belt underneath her clothes. Catherine says, I think Lori should be held in contempt of court for talking that way to the judge. Well, you're not alone, Catherine. A lot of people say that, but think about it. If they held me in contempt of court, I have to go to jail or I'd have to pay a fine. And I wouldn't want to do either. That would severely impact my life. If Lori Vallow has to go to jail, okay, she's already there. If Lori Vallow's issued a fine. She doesn't have any money. I don't know what it's going to do. Sometimes that could elevate a defendant if you said, I'm going to hold you in contempt, which is that case I referenced earlier, the guy that told the judge to do whatever. He said, I'm going to hold you in contempt. And he said, do what you want, mother effer. And it just elevated it. So she could be held in contempt. It's not really not going to do much. Brandon says, are there any updates on a possible interview with Summer after all the text messages were released in the last trial between Lori and Summer on Adam's movements the day before Charles died? That's another person I'd love to talk to. I'd love to talk with Summer. I'll reach out and maybe we can do an interview while I'm here if she's willing to do it. And maybe if you all have questions for her, I could put those to her too. I know that Summer has been friendly with me in communicating, and she's not afraid to answer questions that I have for her. And I've always appreciated that. So, but more questions, of course, did come out of the last trial for sure. Is Ian Pawlowski going to give evidence at this trial? That's what Eileen says. Nope, he's not on the witness list. And in fact, in early October, I don't even think he knew Melanie. They met on an app later, I believe in early November, and then got married 9 days later. And so he was not aware of this in October. Now, maybe down the line he was told, but at that time, as far as I know, he was not aware. Graham and Gramp, is there any penalty that the judge can give Lori for her disrespectful behavior? I don't know. I mean, I guess he could. Well, Brian David Mitchell, remember Elizabeth Sparks' kidnapper? They had to build a special room in the courtroom because all he would do is sing hymns loud and preach. And so they put it in the corner of the courtroom, walled off. There was a window. It was soundproof. Sound was piped in so he could hear, and he could scream and do whatever he wanted the whole time. I don't think Lori needs that, but he could maybe take a break or whatever. I don't know. Violet, is there any way you can find out how Lori's getting bleached for her hair? That is not allowed in commissary. I don't know. I thought I heard someone say that there's a very limited number of hair supplies that are allowed. If you know Maricopa County Jail, I need to research that. There's so much I need to research. I wish there was endless time. Then I can check into that. But yeah. Hogan says, where are Charles's kids in all of this? They are laying low, very low. They have moved on with their life. They're young men now, young adults, and the two sons that he has, and then Colby, of course. We've heard from Colby on and off, and he's, moving on. But yeah, that's where he's at. Do you hear her voice change while speaking to women versus men like the judge? I think she might act a little differently when addressing a woman versus a man. I'll have to listen to the hearing this morning with the female judge, but yeah, that could be interesting to hear if there is a difference. I know when she interviewed with Keith Morrison, her tone was very different than when she interviewed with Brianna from the local news station here in Phoenix. Very different interview. So I think it depends. I think a lot depends on the mood she's in too. It just depends. Do you think the prosecutor will bring up the video from the storage unit with the tire from the Jeep? That's a good question. I think so, but I don't believe so. There's your answer. That's not an answer. I don't believe so. I think it's really strong evidence, in my opinion, because we're able to zoom in and analyze it and talk about who walks like this. And oh, there goes the tire, and there it's moving out, and there goes the car seat, and it's moving out. It's good storytelling, adds blocks to the story, puzzle pieces. But when it comes down to it, the prosecutor has not subpoenaed the owner of that unit. Now, the video is police evidence, so it's possible the Detective Hermosillo, who is going to testify, could speak to that. He's also going to speak to the fact that he seized the Jeep. And maybe they'll go down the line of questioning where, okay, you seized the Jeep. Where did it go then? And meanwhile, you went to the house, and what happened? I mean, we could see some of that, but at the end of the day, it hasn't been brought into the other trials, and I don't know if it'll be brought into this one. Nate, what is CrimeCon? Will you be speaking there, and where is it? CrimeCon is happening in September in Denver, in the West this year. And yes, I'm going to be speaking at it. I'm going to be doing at least 2 panels, and I'm so excited. They haven't announced the subjects yet, but you can probably guess what one of them will be. And the other one, I'm happy to say that I had a big hand in booking. And it's somebody that does not do a lot of these type of events, has never done CrimeCon before. And I think it's going to be fascinating. So you can go to CrimeCon's website. If you use the promo code EATON, EATON, you get 10% off a standard badge. I don't get paid or anything for that. That's just a discount I asked if they could offer for you all to go, because I know that many of you want to go. And Erica's coming with me, and it's going to be fun. We've gone before. We've gone the past few years. Ames 89, what's the difference between standby and assistant counsel? It seems like I've seen others with standby counsel that sit with them at the table and play a more active role than what Lori has. It's all up to her. It's all up to her. In the trial, there were days she wouldn't consult with them at all. Today, she was consulting with them a lot, and she would consult with different attorneys depending on the day. Today, Robert Abernathy was much more involved with her, sitting directly next to her. During the trial, many days, the paralegal was involved with her. It's kind of how she was in Idaho. There were days she was really mad at Jim Archibald, and there were other days she was mad at John Thomas, and so she'd go to one or the other. It's all up to her. If she wants their advice, their counsel, she can confer with them as much as she wants. But they're the same thing. Advisory, standby, same thing. Does she have an attorney for this trial? If not, why is she defending herself again? Sharon asks. We kind of talked about that. She's defending herself because she wants to defend herself. And that's what she's doing there. All right, everybody. Before we go, I want to show you where you can find me. I'm on Facebook, Twitter, X, and Instagram, and East Idaho News YouTube channel. Appreciate you following me everywhere, and appreciate not literally following me everywhere, because if you did that, I'd call the cops. But thank you for following me on social media. Thank you for being here tonight. Before I go, I have to say hello to my wife, Erica, who is feeling a bit under the weather tonight. So think about her if you wouldn't mind, and send all the positive, happy thoughts and prayers and wishes to her, especially because I'm away and she's home with the kids. Last day of school tomorrow for our daughter, for Emmy. She had 6th grade graduation right before I left. I went to her graduation, and then I hopped in the car and drove here to Arizona, but I was able to be there. 6th grade graduation is a thing now. It wasn't when I was a kid, but now it is. And if you missed her interview, I got to show you today the photos. I'm sorry. You can log off if you want now. You don't have to stay with me anymore. But we had this young woman who's organizing a reptile expo. And they offered to do an interview with Emmy. I'm like, yeah, come on in, bring a few of your animals. They showed up with 5 snakes, and I posted these on my Facebook page. Oh, shoot. There we go. Okay. If you go to my Facebook page, Emmy was terrified of these snakes. Like, she wanted nothing to do. This photo of this snake around her neck, it was there for maybe 5 seconds. And we took the picture, and she set it down. My boys, especially Elliot, was in heaven. He could have cared less. Maybe because he's 6 and he doesn't quite understand the snakes. None of these were poisonous, by the way. But this snake loved Elliot. Everett, my son here, loved the bearded dragon. And it's funny because when I was in 6th grade, we had a class iguana named George. And I got to take him home during Christmas. This little guy reminded me so much of George. And Everett loved this guy. And then this dude who looks like a rattlesnake. It's not a rattlesnake. It's a shoot. Actually, I think it's in the comments what type it is. Sorry. It's called a oh shoot, I don't remember. You all know, I'm sure, you snake experts. Anyway, we had this one, and then this 12-foot snake python, I believed, boa constrictor. I'm so bad. This guy was so friendly and so tight, so heavy. I carried him around our building. He was so heavy when I went over to show some of our colleagues that my shoulders felt like they got a workout. And someone's messaging me, Nate. And then there's Elliot loved this little dude too, this long dude, and then he loved this snake. And there we are with the big one. And there's our family holding all of these big, fun, cozy, cuddly critters. And there we are, scared for our lives. You can watch Emmy's interview at eastidahonews.com or on our YouTube channel. There's a reptile expo this weekend that I think the kids are going to try to go to. I'll be here in Arizona, but I will be back here tomorrow night, Courtroom Insider, as we get the jury, posting live updates tomorrow. Thank you all for watching. I hope you have a great night. We'll see you tomorrow.